Thank you, Chairman, members of the committee. If I may ask a point of clarification to the Chairman.
Certainly.
Is the committee taking testimony on Monday, or are you hoping to have testimony?
Yes, we will be.
Then I will keep my comments short.
You will, if you testify today, you will not be able to testify on Monday, however.
Okay.
We will keep track of it.
Then I will testify today. Good morning, Mr. Chairman, members of the committee. My name is Monica Hopkins, and as the Executive Director of the American Civil Liberties Union of Idaho, and on behalf of the 2,000 ACLU members in the state of Idaho, I am here to express our concerns about House Bill 380 and now House Bill 404. In First Amendment cases, the government carries the burden of proving constitutionality of its actions. The problem that distinguishes this instance from the reference Clark case is the regulation had been in effect for 43 years before it was invoked against the protesters. This bill is modeled after the Boise City Camping Ordinance, which has been litigated since 2009 and continues to be litigated in the Ninth Circuit Court of Appeals. It seems problematic and irresponsible to fashion and fast-track a piece of legislation that models itself after an ordinance that has been litigated for 2 years and which leaves the state open to litigation at the expense of Idaho's taxpayers. The enactment of the emergency provision and no notice provision within the bill allows authorized persons to seize and dispose of property without due process, and again opens the state to potential litigation and exposes such authorized persons disposing of said property to potential misconduct suits. The Occupy movement seeks to redress government practices that increase economic inequality, and in Idaho, where the homeless population has jumped 37% from 2007 to 2010, a statute such as this one may serve to further intimidate and harass the homeless, particularly for the involuntary and necessary action of sleeping. The fiscal note implies that there is no impact to the general fund. However, there is a cost associated with assigning personnel to take down these camps and costs associated with the removal and disposal of personal property, and potentially arresting and detaining individuals, especially when in other cities, occupiers have been willing to be arrested and go to jail in defense of their First Amendment rights. We look to our legislative leaders, to this committee, to engage in inquiry and conversations, to learn the concerns of their constituents, and endeavor to end the need for this type of redress of government, for this type of assembly, and for this type of expression, and craft solutions to the state's problems, not nullify First Amendment rights at the expense of Idaho's taxpayers. Therefore, we urge you to vote no on House Bill 380 and no on House Bill 404. Thank you. I stand for questions.
Thank you, Mr. Chairman. Ms. Hopkins, was it?
Yes.
You mentioned the specter of arrest, but the particular bill only sets up an infraction process. So where are you getting that arrest?
Well, the potential of police misconduct and the potential of those altercations that have occurred in other cities between law enforcement and occupiers, some of which in other cities have been very peaceful, but have ended in police misconduct, have ended in the arrest, peaceful arrest of folks. There is an infraction, but it is not outside of the specter that there could be arrests.
Further questions? Thank you.